Hello and welcome to everybody joining us on Lathrop GPM webinar on dealing with franchisee trust ownership arrangements. My name is Galen Knack. I'm a partner, I'd say the Minneapolis office of Lathrop GPM, but it's actually my home office, as many of you may also be viewing this webinar from your home. I'll be moderating this session today. And with me as panelists, the experts that I will lean on are Scott Mallon and Edward Tully. Both Scott and Edward are partners here at Lathrop GPM and work in the trust estates and legacy planning area. And as this webinar focuses on trust aspects and how they relate to franchise systems, they are my go-to guys when I am dealing with trust issues that franchisors bring to the table. And between the two of them, they have many years of experience in dealing with trust estates, legacy planning, and often help franchisors in dealing with issues that come up. Before we get started, a few administrative notes that I want to pass on. First of all, I want to let you know that we welcome questions during the presentation. If you have a question anytime, just use the chat feature to submit those questions. We'll try to get to as many of those as we can today. We'll also save a little bit of time at the end if possible. If we don't get to all of them during the presentation, we'd be happy to follow up with you after the webinar to answer those questions. In addition, the webinar will be recorded and available on our website by this coming Monday, along with a copy of the slides. You'll all receive a follow-up email directing you to that page on our website, and we welcome you to share that with others in your organization. And finally, there will be CLE credit applied for in Missouri and Minnesota, and follow-up information will be sent following approval. So we thank you for the introductions, and with that, we're going to move just to a quick overview as to what we're going to cover today. So as many franchisors know, we face franchisee population that is aging. And when we talk about trust, it's always important to put this into perspective and talking briefly about business succession planning. So we'll start with that. Then we're going to spend some time focusing on trust structures, an overview of that, types of trust, fiduciary roles. And I think we won't go into great detail there, but I think certainly cover the basis so that franchisors have a general grasp of the issue. Also understand the benefits of a trust, as well as how to handle franchisee trust ownership. We'll discuss triggering events as applied to trusts and transfers involving trusts. We'll look at some of the pitfalls and challenges that franchisors face involving trust ownership. And then we'll finish up with a few takeaways for franchisors to consider in dealing with this issue. So with that, we're going to start off, as I indicated, with some business succession planning, just an overview, and keeping that in perspective as we think through the issues that tie in with trust ownership. And I'm going to turn it over to Scott here just to discuss a little bit of the business succession planning issues that come into play.
Thanks, Galen. So what is business succession planning? It's really dealing with the transition of a business to the next owners and sometimes the next generation. It applies to your franchisees because as as Galen indicated, as they age and as they want to move their business down or sell their business or maybe transition it to their family, this is something that they're going to address. And as the franchisor, you want to make sure you have some control over that, obviously. And Edward's going to get into a lot of detail about that as we go forward. It also may apply to some of you as franchisors, as your businesses. If your businesses are closely held businesses, it's an issue that you may want to deal with at some point. It's challenging because it takes a lot of time, it takes a lot of thought, it takes a lot of effort. And business owners are dealing with the business every day, operating the business, putting out the fires and running the business. And so this often gets put on the back burner, but that's not really ideal. And as you can see the statistic up there, that 30% of family businesses make it to the second generation and only 12% to the third. That's one of the reasons people don't put the time or effort into planning the succession or the transition. There are other reasons as well. Sometimes there's not an appropriate person to transition it to, so they end up selling the business. And but that is part of the plan, and that's often part of the process to determine whether there is a potential transition. And it may be that the ultimate end is to sell that business. The two main parts to succession planning are ownership succession and management succession. Ownership succession is exactly that. It's who owns the business, who's going to own it going forward. And that's often where people focus their attention. That's where a lot of attorneys focus their attention. But management succession is at least as important and often more important. And that's who's going to run the business, who's going to be in charge of it going forward after you do the transition. It's not necessarily the same as the owner. In many cases it is, but there are many businesses that privately held where the owners are not the managers. The company may be run by an independent CEO or some other independent person to run the business, and some very, very successful businesses that handle it that way. So I'm going to turn it over to Edward now to get into some more of the detail on some of the issues that come up in the succession or the transition planning for some of the franchisees.
Thanks, Scott. So as a trust and estates attorney, I work with individuals, families, business owners on developing estate plans and business succession plans. And for the most part, those plans use trust arrangements really to kind of facilitate and implement how those plans transfer wealth to one generation to the next. On the flip side, I also work with franchisors to review and analyze estate plans and propose transfers to trusts by franchisees to ensure that that the franchisor's interests are protected in those type of arrangements. But before we get into some of the franchise-specific trust issues, we thought it would be helpful to give you kind of an overview of the trust structure. Kind of what is a trust? What are the roles? Who are the key players? What types of trust you may run into, and then kind of the reasoning behind why franchisees are kind of going towards these trust arrangements. So at its most basic level, a trust is a fiduciary arrangement under state law. So you have one person who's generally referred to as a settlor, who transfers property, and it could be any type of property, to another person who's referred to as a trustee. And the trustee receives that property, and the trustee receives it not for the trustee's own personal benefit, but instead the trustee is holding that property for the benefit of another person or multiple persons who we refer to as beneficiaries. This relationship is a fiduciary relationship, meaning that the trustee owes the beneficiary certain duties, responsibilities, and obligations to hold that property, to manage that property properly for the benefit of the beneficiaries. And if the trustee doesn't do that, if the trustee violates his or her rights and obligations, then the beneficiaries could have recourse against the trustee. The trusts are usually created under trust agreements, and a trust agreement is basically a contract that is entered into by the settlor and usually by a trustee, usually not the beneficiary, so usually they're not parties. But the purpose of the trust agreement is to really kind of outline the terms and provisions regarding how the trust is going to be administered, how the property is going to be managed, and how the property will ultimately be distributed for the benefit of the beneficiaries. It's important to note that the trust only controls property that's actually transferred to and held by the trust. So when you create a trust, it's really a two-step process. So you're creating the trust, but then you have to actually fund the trust, meaning that you have to transfer property to the trust in order for that property to be subject to that trust arrangement. So the trust agreement will really does two primary things. It'll outline kind of who's responsible for managing the property, how it's to be managed, how it's to be invested, which is, particularly important from a franchisor's perspective, because if you have a franchisee entity that's getting transferred to one of these trust type arrangements, you're going to want to know who is going to be responsible for controlling and investing that interest, because they're going to be the ones who are ultimately going to be making decisions regarding how that franchisee entity and ultimately the franchise is managed. Also, yeah.
Edward, I'm going to throw in a question for you here. You mentioned just a little bit earlier that the trustee has a fiduciary duty to the beneficiaries, right? Is there the potential, given that duty that a trustee has, to end up creating some conflict with the obligation to the franchisor under the franchise agreement? It seems like there might be two different obligations. Is that possible? Are there conflicts that can come up in terms of the obligation of the trustee?
I think the answer is potentially yes. I think so, and we'll get into a little bit later about when we transfer these type of interests to a trust and kind of what the trustee is going to need to be entering into the franchise agreement, and is going to be taking on certain obligations and responsibilities under that franchise agreement. But you're exactly right, is that it's on the trustee to ensure that whatever the franchise or whatever the trustee is agreeing to in that franchise agreement is consistent with and doesn't, is not contrary to the obligations that trustee is going to owe to the beneficiaries. So I think, that it's a good point to bring up, and I think it's probably more on the trustee to ensure that the trustee is not violating his or her fiduciary duty by entering into that franchise agreement. And sometimes, when we approach the trustee with changes to the franchise agreement or with certain representations that we want the trustee to make, that may be some of the pushback we get from the trustee, is that the trustee has other considerations to think about that and may not be able to agree to that in a franchise agreement.
Okay, thank you.
Okay, and so also in the trust agreements, not just, how the property is going to be managed, but also how it's going to be distributed out to beneficiaries, which is going to be important because the property, while it's held by the trust, it's going to be the trustee who's going to be responsible for investing it. But when it comes out of the trust, for example, to the beneficiaries, then the beneficiaries are going to own it and control it. So it's important to understand kind of how that structure is done in the trust agreement. Okay, I think we can move to the next slide. Okay, so what are the roles in a trust? So the settlor, and this could also be referred to as a grantor or a trustor. So this is the person who is transferring assets to the trustee. And what's important to note here is that depending on the type of the trust, and we'll get into that in a little bit, but the settlor may not have any continuing power or control over the trust and ultimately over the trust property after the settlor transfers the property to the trust. So depending on the type of the trust, the settlor may not be that important of a role moving forward. Now the trustee, this is the person who's receiving the trust property. This is the person who is probably going to be investing the trust property, controlling the trust property, and ultimately making decisions regarding when and how the trust property is distributed to the beneficiaries. It's important to note here that the trustee could be an individual. It also could be a bank, could be a trust company. There could be multiple trustees. So you could have a situation where you have a trust with 2 or 3 or 4 trustees all serving as co-trustees. And in that situation, it's important that you understand, how they make decisions. Is it a majority decision? Is it a unanimous decision? And kind of how that's going to work. I'm going to skip the trust advisors and trust protectors for now and just focus on the beneficiaries. So these are the individuals who the trust is created for. So, they're the ones who are the ultimate beneficiaries of the trust, receive the trust assets when it comes out of the trust. It's important to note that the beneficiaries don't own the trust assets. The trust assets are owned by the trust, and the beneficiaries have what's called a beneficial interest in the trust, but they don't actually own the assets of the trust. And that creates some protections for the beneficiaries for example, creditors, because the beneficiaries don't actually own the assets, they only have a beneficial interest in the trust. Now, for most trusts that you're going to come across, those 3 roles, the settlor, the trustee, and the beneficiaries, are going to probably be the only roles that you need to worry about. However, there are more complex trust arrangements that have other roles, other fiduciaries who are involved. And if you have a trust with those type of positions, you really want to make sure that you understand who those persons are and what their potential control is over the trust property. So for example, in a lot of trusts that we create, we'll have trust advisors. So this could be 1 or more individuals who have the ability to advise the trustee or even direct the trustee, a mandatory direction to the trustee on certain decisions regarding the investment of trust property or the distribution of trust property. So if you have a trust that has 1 or more of these advisors, it's very possible that the real power with the trust, in other words, the real control over the trust property, is not with the trustee, but is with 1 of these trust advisors. Similarly, there could be what's called a trust protector. Generally, this is kind of an oversight role. So you have someone who has oversight over the trustee, who could veto decisions made by the trustee, could override decisions, could remove and replace the trustee. This can be a very powerful role in a trust. So if you have a trust that has 1 of these trust protectors, you're going to want to know who that person is and kind of what their role is, because it's very possible that they could remove the trustee and take complete control of the trust property at any time. One other thing I just want to mention here is one role that's not here is a personal representative or an executor. So you may come across in dealing with estate plans of franchisees, a personal representative and executor, and those are persons who control a decedent's estate. And we're going to talk a little bit more about how that works at death and what that role looks like. But generally, a personal representative or an executor is really not going to have any control over a trust and property that's held by that trust. Go to the next slide. Okay, so categories of trust. There's 2 primary categories that I think you really need to be aware of, that most trusts are going to fall into 1 of these categories. It's either a revocable trust, also referred to as a living trust, or an irrevocable trust. So first, focusing on a revocable trust, which I refer to as a will substitute. Really what this is that this is a trust that's designed to avoid probate at death. So when you die, you don't have a revocable trust. Generally, your assets are going to have to go through a probate proceeding where you submit a will to the court and you have an oversight or a judge overseeing the administration of the estate and the ultimate distribution of the assets to the beneficiaries. It can take a lot of time. It can be very expensive. So a lot of times people want to get away from that structure and move to a revocable trust. And a revocable trust is a trust that you transfer assets to during your life. And during your life, the trust owns the assets, but you can revoke the trust at any time. You can amend the trust at any time. You can put assets in. You can take assets out. really during your lifetime, it's just a conduit for you. You have complete control over the trust property. And, you know, in fact, all of the income from the trust is reported on your 1040. It's really not its own tax entity. So from a practical standpoint, generally the settlor is also the trustee. So when a transfer is made to a revocable trust, usually there's not really a change of control regarding the property that's transferred to the trust. So if I create a revocable trust and transfer assets to that revocable trust, I'm probably also going to be the trustee. I'm going to retain control over it. And so there's really not a change of control when you transfer assets to that revocable trust. Compare that with an irrevocable trust, which is a much different structure. An irrevocable trust can be created during life or at death. And the key distinction here is that the settlor really, in most situations, doesn't have any control over that trust or over that trust property after that trust is created and after it is funded. These type of trusts, and Scott's going to get into this in a little more detail in a minute here, but really these trusts are created for a specific purpose, whether it's tax planning, asset protection planning, business succession planning, and really, you know, once the settlor transfers the assets to that irrevocable trust, there's a change of control, and it's really not the settlor who's going to control the assets. It's going to be the trustee, or, you know, potentially those other roles that we just talked about, who are now going to be controlling the trust property. And now from a franchisor's perspective, this distinction between revocable trust and irrevocable trust is very important. You know, it's important that you understand it, and it's important that you properly identify it, because when we're going to talk about a little bit later about kind of the steps we need to take from a franchisor standpoint with regards to transfers to these trusts, probably step one is figuring out whether it's a revocable trust or whether it's an irrevocable trust, because that distinction is going to change the approach that you might need to take on how you whether approve or review that transfer. And with that, I'm going to turn it over to Scott, who's going to talk a little bit more about some of the different types of trusts and the benefits of trusts.
Thanks, Edward. So Edward mentioned the revocable trusts versus irrevocable trusts and the advantages of revocable trust, living trust. That's what you're likely to see most of the time. Someone who's doing this as part of their basic estate plan, get their interest in the business titled in a revocable trust. That's good for you. It makes it a much easier transition if something happens to them. It avoids going through probate. It avoids dealing with the courts. It avoids the delays that go along with the courts, and it avoids the public records of the courts, because if it goes through an estate, through a will, that's all public record, and including the ownership, and some information is going to be required related to their business and the franchisee. So that's something that you should encourage and want, that your franchisees have their business interests owned in irrevocable trusts. And Edward mentioned this, but you can create the trust. It's basically disregarded for tax purposes and most other purposes. The trustee is going to typically control it, so that's a good thing. And upon death, it will continue on. It does become irrevocable. It turns into an irrevocable trust upon death, but the asset's already owned by that trust, and so it doesn't have to go through the courts and the probate process. So that's I think what you're going to see most commonly, and should be encouraged, because it'll make things a lot easier from the standpoint of transitioning the business. There are multiple different types of irrevocable trusts. I just listed a few of them here. An irrevocable gift trust is part of an estate plan or a succession plan, where an owner might want to move some of the shares into a trust for the benefit of the children, or maybe it's the next person who's going to take over the business if something happens to them. It's usually done really, as I said, for estate planning purposes, to remove the assets, to remove the business interest from the owner's estate for estate tax purposes, to get it out of that person's estate, and maybe to get that next person a little more involved. So you're shifting the beneficial ownership at that time, and so as mentioned, it's different than putting it in a revocable trust. And you're also typically shifting the control, because the trustee is not going to be the same person as the grantor, the settlor who set up the trust. Another type of trust is an insurance trust. And these obviously own life insurance policies, but it's often coordinated with part of the plan. And insurance is in a lot of cases an important aspect of a succession plan or an estate plan, especially where there are a lot of business interests involved, and that's an illiquid asset. So in a lot of cases, they need those policies, they need those trusts in order to provide some liquidity, whether it's for lender purposes or for their own family purposes. Those tend to be irrevocable trusts because you don't want to include life insurance proceeds in an estate for tax purposes. So in most of the case, those are not revocable, those are irrevocable trusts. Another type of trust is an asset protection trust. And the idea behind the asset protection trust is that you're putting assets in that trust, and then those assets in the trust cannot be attached by creditors. And there's lots of different types of asset protection trusts. Some can be created during your lifetime. I can create a trust in some states for myself with certain restrictions, and the assets that I put in that trust will be protected. So if I get sued, they can't go after those trusts. More common is an asset protection trust created by a third person. So I might create a trust for my child or my children, either during life or upon death. I'm going to keep those assets in that trust because I want them to be protected. So if the child gets sued, or if something happens to a marriage for a child, those assets are protected, and neither the creditor nor a spouse could go after that. That's something to keep an eye on, because if you have a franchisee and you see that their assets are in an asset protection trust, or the assets as they get transitioned are in an asset protection trust, there's a pretty good chance you're not going to be able to get to those, whether it's to satisfy a guarantee or any other liability. So it's just something you want to keep your eye out for. And the last one I have listed here are just charitable trusts. And that's a whole separate animal in and of itself, but you occasionally see those for people who are charitably inclined, and they have often have significant income tax benefits and estate tax benefits.
Scott,
Yeah.
just briefly, asset protection trusts. Are they easy to spot? I'm assuming the title is not asset protection trust. It says something else, but is it pretty easy from looking at it that a trust may fit into that category?
If it's an irrevocable trust, you have to look at it to see that. In many cases, probably in most cases, an irrevocable trust is going to be protected from that person's creditors. But you really can't tell without looking at the terms of the trust. A revocable trust provides no protection from an asset protection standpoint. As Edward said, that's a will substitute, really. But once a trust becomes irrevocable, in most cases, there's going to be an asset protection feature to it.
Okay.
Seth, can I add one thing? So I think Scott's exactly right, that you're not really going to be able to tell unless you get into the trust agreement. But one thing that may be kind of a red flag is, different jurisdictions, different states have different trust laws, different tax laws, and some states are more favorable than others regarding these asset protection issues. For example, South Dakota, Delaware, Nevada, Alaska, all of those states have very favorable asset protection laws. So if you have a trust, for example, for like a Michigan resident that's in South Dakota, is in one of those other jurisdictions, that may be a red flag for you to take a look at it, that there may be more going on. There may be a reason why we're moving jurisdictions.
Yeah, that's a really good point. You may have them in your own jurisdiction, but if you see those jurisdictions that Edward mentioned, Delaware, South Dakota, Alaska, those are almost certainly going to be set up to protect assets. That would be the only reason people would be going to those jurisdictions. So talking about some of the benefits, we've mentioned several of these already, but for a revocable trust, the real benefit is avoiding probate again, so you don't have to go through the court process. Privacy, that's true of revocable trust and irrevocable trust. There is no, generally speaking, there's no public filing for a revocable trust. There's no public information as far as what the trust says or what's in the trust. It's a private document, and so most people like that advantage, but from your standpoint, you need them to provide it to you so you can see the terms of the trust and make sure it complies with your agreements and make sure it does what you want it to do. Amendable, again, that's only if it's a revocable amendable trust. Irrevocable trust generally cannot be amended, although there are ways around that in many states and in many circumstances. They may not be called an amendment, but there's often a lot of flexibility built in there that allows you to make changes to the terms of the trust. So if someone tells you they can't change the terms of the trust because it's quote irrevocable, you might want to check into that a little further, or call any of us and we can look at it, because there may be a way around that. The assets are available immediately. That's specific really to the revocable trust upon death, or also upon disability or incapacity. The trust just continues on and doesn't have to go through any court processes. The last three, tax planning, that applies to almost any type of trust. That's one of the real benefits and is the purpose for a lot of trusts. That can be, as I said before, estate tax planning, try to remove assets from an estate so you don't pay an estate tax upon death, but also income tax planning to try to get the income taxed at the lowest bracket that you can, whether it's a certain individual or whether it's a trust. Controlling the inheritance for heirs, that's obviously an important point for a lot of people. They set up these trusts because they don't want to give their assets outright to their heirs. And that could be for a variety of reasons. Again, it may be protection against a potential creditor or a spouse. It may be because the beneficiaries are too young and they're not at the age that they are ready to handle the assets or to handle the inheritance. It may be that the beneficiary has other issues, whether it be a gambling addiction or a dependency issue. So there's all sorts of reasons that people want to control that inheritance, but many, many different ways to do it, and many, many important reasons. And then the last one is asset protection, which again, we've talked about that quite a bit already. And that can be a trust that you create for yourself in certain states, or it can be a trust that someone creates for you. And in that case, almost every state provides some protection for that. So I'm going to turn it back over to
Scott. I've got a question for you before we turn it back over to Edward. Single purpose versus multi-purpose trust. And maybe it's a question for either one of you two. Is there a reason a franchisor would want the franchisee to have the only asset in the trust be the ownership interest in the franchisee entity versus commingling it with other assets? Is there an importance for a franchisor to require that it be a sole asset in that trust versus commingling?
Well, I'll mention the single purpose and the multi-purpose, and I think Edward will probably have something to add to this. But yeah, I think you articulated that well, that you could have a trust that the sole purpose is to own the franchise business, for the franchisee to own their interest. Or you can have a trust that has multiple purposes, that owns not just my franchise, but it owns my house and my investments and my cash or whatever else I have. I think ideally you'd rather it be a single purpose trust, because then it will be specific, and the terms of that trust will be specific to address the concerns that you have, many of which Edward are going to get into. If it's a multi-purpose trust, it's going to be more generic, and it's going to cover all sorts of different assets and all sorts of different things, and it is likely not to be as specific to address the issues that you have with the franchise.
Mm-hmm. Yeah, so just a couple of things to add there. I mean, I think that there's benefits on isolating the franchisee entity by itself. You don't know what other assets are going to be in the trust, what other type of, creditor risks those other assets may have. So isolating the assets, there's some advantages there. I think we also see it frequently from the franchisee's perspective. That, for example, if the franchisee is wanting to transition the business to one of their children or two of their children, and maybe they have 4 children, and you may want a separate trust that only those 2 children, who maybe those are the ones who are involved in the business, maybe they're the only ones who are beneficiaries of that trust, and not the other children, or maybe not the other beneficiaries, other people who are part of their more general estate plan. Because beneficiaries in most jurisdictions have certain rights to information regarding the trust. So there could be some advantages to isolating certain assets, so you don't have one person who really doesn't have any interest and who's not going to have any interest in the franchisee entity getting information or having any access to that information regarding the franchise.
Yeah, just one more thing to add, where I think there's often confusion, is you have a revocable trust. During your lifetime, it's a revocable trust. Upon death, it creates these other trusts. It might create a multi-purpose. It might create a single purpose. It might create an asset protection trust. Often I see people are looking, you see this with lenders and other institutions, they're looking for another document that says, the franchise trust or the asset protection trust. It's all in the same document in many cases, not always. If it's an irrevocable trust you create now, it very well may be a separate document, but the irrevocable trust document often has the terms for not just the revocable trust, but everything that happens after death. And that can be multiple different trusts, all created within the same document. So if you're looking for the terms, they may all be in that revocable trust, depending on the circumstances.
Okay, thanks, guys. Moving on to the next one. So, Edward, I'm a franchisor, and email comes in from a franchisee. Ideally before it happens, but let's say that a franchisee says, just want to let you know I'm moving my ownership interest in the franchisee entity over to a trust. I'm assuming that's okay. Let me know otherwise. How do you deal with that situation, Edward?
Okay. So I think, from the franchisor's perspective, what the franchisor is primarily concerned about is control. Who controls that franchisee entity. So there's a few options on kind of how you can go about from a franchisor on gathering information and trying to determine what's being transferred, what's this new trust, who controls it, who benefits from it. I think you probably have three options. The first option is you just do nothing, right? You just let the transfer happen. And there's some risks there because this transfer could be going to some trust, and that trust could be controlled by somebody who you don't know, you haven't vetted, and all of a sudden that person is now going to be controlling the franchise. So there's certainly some risks there. Option two is gather some information and update the franchise documents. So you're going to need to update the franchise documents to show the trust as the new owner. You're going to want, the trustee, assuming the trustee is the one who's going to be controlling the trust, to be a party to the franchise agreement. There could be some representations in those documents regarding the structure, but you're not really doing a deep dive into the documents themselves. So you're not reviewing the trust documents to really take a look at the structure. You're more relying on representations from the franchisee regarding what is being done. And in a lot of situations, that may be the right answer. And then the final option is you do a deep dive. And that's what we're going to talk about here is kind of, if you're going to do a deep dive, kind of all the documents that you need to take a look at and kind of what issues you need to be analyzing. But I think step one is, and we talked about this earlier, is we need to figure out, are we transferring it to a revocable trust or are we transferring it to an irrevocable trust? Because if the transfer is going from an individual franchisee to a revocable trust of which the individual franchisee is the settlor and the trustee, there's really no change of control there. That same individual is still going to be controlling the franchisee entity. And in that situation, you probably don't need to do a super deep dive into the documents. Updating the documents to show who the new owner is probably, in most situations, an appropriate course of action. Now, if you're doing a transfer to an irrevocable trust, and we're going to be having a new trustee who's going to be controlling the franchisee entity, in a lot of situations, you're going to want a little bit more. You're going to want to request copies of the trust agreement itself, so you can take a look at the control provisions and you can know who all the key players are. You're going to want to request any amendments to that trust agreement. Scott mentioned earlier that even though it's an irrevocable trust, a little counterintuitive, that doesn't mean that it hasn't been amended. There are ways to amend that trust. So you want to make sure that whatever you do get as far as the trust agreement goes, that it's a complete trust agreement with all amendments. Now, the trust agreement should show, who the parties are, who the trustee is, but that trust agreement may be 20 years old. So there may have been some changes from a trustee succession standpoint, and the individual or the bank or whomever who's named in that document may not be the current trustee. So we also want to request the trustee succession documents resignation instruments, acceptance instruments. So we've got a good picture of the complete trust agreement and all of the key players and all of the roles that they're currently serving in. One thing I do want to mention is sometimes we'll request to these documents, a copy of the full trust agreement, and what we will get back from the franchisee or the franchisee's attorney is what's called a trust certificate. And a trust certificate is a document that's authorized usually by local law, by state law, and it's basically a summary of the trust. It shows what the official name of the trust is, it shows who the trustee is, and it may show a couple trustee powers. It's better than nothing. It's a good summary of the trust, but it's not a complete picture. And, for example, if you have one of those more complex trusts where we have advisors who really have control over the trustee, that's probably not going to be shown in that certificate. So, back to those steps we talked about earlier, step one, do nothing. Step two, just kind of update the franchise documents and rely on representations. If we're going that step two route, then, getting a copy of that trust certificate, that could help. That's helpful. That's better than nothing. But if we're really trying to deal with a complex transfer structure, that's not going to show us what we need as far as the trust documents go. Also, you're going to want to request the corporate documents. A lot of times as part of this succession planning, transferring assets to trust, they're also going to be updating, the buy-sell provisions, the operating agreement, bylaws. So we just want to make sure that we get copies of all of those applicable documents so we can take a look and make sure that we fully understand what's going on. And then, of course, we talked about this earlier, there's two steps in any trust. There's the creation of the trust, and then there's the transfer of the assets to the trust. So not only do we need the trust agreement, but we need that assignment from the individual to the trust. So we've got evidence that it's actually been transferred to that trust. So, and then once you have the documents, then I think it's really just taking a look at them, trying to really identify those issues about who controls it. Is it the trustee? Is there somebody else who's got control over the trustee? And then also looking at change of control events. So, I draft a lot of trust agreements. Scott drafts a lot of trust agreements. Flexibility is the name of the game in these trust agreements. So these trust agreements are going to have provisions for removing the trustee appointing a successor trustee, beneficiaries removing trustees, all sorts of different things that's going to allow for flexibility in changing who controls that trust. So we just want to make sure that we fully understand what those events are, when they could occur, how they could occur. So in a second here, we're going to talk about franchise agreement and some of those triggering events. And so just keep that in mind on these change of control events under the documents, because we're going to want to tie those to the franchise agreement to make sure that we're covered in any event. And then the last one on here, once the franchise entity is transferred to the trust, we just want to make sure that we can follow, what happens to that entity. Because a lot of times in a trust agreement, assets get transferred to a trust, but then other things happen, subsequent events, deaths, beneficiaries attaining certain ages that could cause that trust property to either go out of the trust or move to a different trust. So just want to make sure that you fully understand kind of what's going on in that trust agreement. Okay, so that was kind of focusing in on lifetime transfer. So settlor creates a trust, transfers it to a trust during life. The other situation where you may be dealing with transfers to trust is at death. So if you have a franchisee who dies, the question is going to be, what happens to that franchisee or that individual franchisee's interest in the entity? Where does it go? Step one is you need to figure out how it's held, who owns it. So does the decedent, the individual, is it just owned by the individual? Has there not been any transfer to a trust, and it's just owned by the individual? Another option is it's owned by the individual, but the corporate documents provide for what's called a transfer on death designation, or some kind of transfer on death to occur at that individual's death. So we need to take a look at that and see whether that is in play, and if it is, then we need to know where that's going. And then third, it could be owned by a revocable trust. And we talked about earlier the benefits of creating these revocable trust agreements. And the primary one is to avoid a probate process at death. So if you have a franchisee entity that's already been transferred to a revocable trust, then, we avoid probate and we can kind of, take a look at that plan under that revocable trust agreement in isolation without having to worry about a probate proceeding, which we'll talk about in a second. So those are really the three options. So starting with the revocable trust. So if you've got a situation where the decedent, the individual franchisee during life transferred that ownership interest in the entity to a revocable trust, hopefully with your review and approval, now I think is the time if for example, if you were in the option 1 or the option 2 camp where you did nothing, or if you only just relied on representations from the franchisee and updating the franchise agreement but didn't really get copies of the documents, now would be the time to request the copies of the documents of the revocable trust, because now is when it's actually going to be transferred. So the settlor is deceased. Now we have a transfer and control, and we're going to want to know where that interest is going. Is it going further into trust? Is it going outright to beneficiaries? So I think you can take a look at the previous slide and all of that information regarding, a copy of the revocable trust agreement, copy of assignments, copies of amendments, trustee succession documents. If you don't already have those documents, now's the time to get those documents so that we can properly, figure out where the interest is going and kind of who we're going to be dealing with from the franchisor's perspective. If the interest is owned by the decedent individually, but if there's a transfer on death designation, now what that transfer on death designation does is it's an automatic transfer. So when the decedent dies, it automatically transfers to that named beneficiary in the TOD. So that avoids probate. So this is another way to avoid probate. But we want to make sure that that TOD is authorized under local law. So I can tell you from a lot of experience that not all states permit these privately held entities to do these type of transfer on death arrangements. Now it's not on the franchisor to do that research about whether the state allows for these type of arrangements, but it is a good idea in the updates to the franchise agreement and updates to the consent agreement that we're going to talk about in a minute, in the representations, for them to make a representation that yes, this is transferred pursuant to a TOD. Yes, it's permitted pursuant to this state's law, and for them to really take the liability risk away from the franchisor on those transfers.
Edward, and I know want to make sure we have enough time to cover the last few slides, but a question, a couple of times both of you have talked about avoiding probate. What's the big downside of probate? What's the challenge there for a franchisor? And if it is such a challenge, what can franchisors do to encourage franchisees to avoid that situation?
So for me, I'll let Scott answer, but for me, from the franchisor's perspective, it's a timing thing. I mean, these probate proceedings, and it varies state by state. Some states probate proceedings are pretty efficient and can be done pretty quickly. Other states, it can take a lot of time. And so there's just a lot of transition time there that you have to deal with this probate proceeding where, you may have, X child who's supposed to be receiving these interests, but we have to wait for this probate proceeding to carry itself out. And so from the franchisor's perspective, we may be in this interim period having to deal with somebody else, whether it's a personal representative, an executor. So it's almost like you're having to do two transitions from the franchisor's perspective. First, from the decedent to the estate, and then second, from the estate to whomever is going to be ultimately receiving the interest. So it kind of, elongates the whole process and just takes a lot more time and expense for everybody.
And one more thing about that is, and it very obviously, as Edward said, it really varies depending on what county and what state you're in as far as the timing. But you have a time frame, and especially during COVID now, in some states, I know I'm in St. Louis, Missouri, it could take 6 weeks to get the authorization of the court to appoint that person who has the authority. So in this interim period, which could be a month or 2 months these days, nobody has control of the company. It's locked in sort of no man's land, and that can become a real problem.
Mhm.
Yeah, definitely, especially if it's a type of a setting franchise like a retail franchise or hotel or something like that, where you need to make sure you have someone in charge of running the ship during that period. Why don't we move on and just briefly touch on some of the triggering events applied to trust?
Yeah, so, we've been talking about, on these transfers, lifetime or a death, that we need to, get all these documents, all this information from the franchisee. But equally important is that we need to review the franchise agreement to see what it says about transfers to trust and about change of control events. Because obviously the goal is that we want, any type of change of control, whether it's a transfer to a trust or a change of control of the trustee, to be a triggering event that allows or that requires the franchisee to notify the franchisor of the event, and it requires the franchisor to consent to it, to properly take a look at everything, see whether it makes sense from the franchisor's perspective, and either approve or reject it. So under the franchise agreement, we want to make sure that, obviously transfers to trusts is a triggering event. We want to make sure that once it's held by the trust, that the transfer from that trust to a beneficiary to another trust, that's a triggering event that's going to require the franchisor's consent. If there's a change of trustee, so, we may approve the transfer to this trust based on X serving as trustee, but if X resigns and all of a sudden now we're dealing with Y, we want to make sure that that's a triggering event so that we get notified and we can either approve or go through the process there. And, really any of those other fiduciary roles, the advisors, anything that affects control, we want to make sure that those are triggering events. And then just briefly on death and incapacity, typically in a franchise agreement, when an individual owns the interest, death and incapacity are going to be triggering events, but a trust can't really die. A trust can't really become incapacitated. A trustee can, a settlor can. So we want to make sure that there's a connection there between, applying those type of triggering events to the fiduciary roles instead of in the individuals.
And I'm assuming, Edward, you've got a number of different triggering events here that, as we've learned, you don't always have to have all of this in a standard form franchise agreement. You can deal with it through an amendment to the franchise agreement specific to that trust, correct?
Absolutely, yeah. So if we go to the next slide here, so as part of these transfers, what do we need to do from a franchisor's perspective? Going to bullet point 2 there is, we want to make sure, if the current franchise agreement really doesn't contemplate trust ownership, then we want to make sure that we do an addendum to that franchise agreement as part of consenting to the transfer to the trust, that ensures that all of these triggering events are all in the future going to require the franchisor's subsequent consent. So we're making sure that that we're covered after it's transferred to the trust, because once it goes in the trust, that's just step one. Eventually, it's going to come out of the trust. It's going to go somewhere else. So we just want to make sure that we're anticipating those future transfers.
So what we're going to want to do is amend the agreement through that addendum to require, for instance, a franchisee to obtain consent before there's a change of trustees, right?
Correct.
Okay. And typically the way we've worked with these is that a lot of franchisors have kind of a standard form assignment and consent agreement. And that's what we use because this is a transfer. And we'll talk a little bit about making sure it constitutes a transfer that requires consent. But typically we'll work off of those types of forms and then adjust it as needed to deal with the specific trust situation. On the personal guarantee, guys, obviously we look to maybe some different actors being guarantors, including the trustee, right, Edward, in most situations?
Correct. So, as part of as part of this, we probably, if we had an individual franchisee, now we're going to a trust franchisee. That individual probably had a personal guarantee. We want to make sure that we're carrying over that same concept to the new owner. So, typically we would want the trustee to sign a personal guarantee, not personally. So it's not the trustee's own personal assets, it's the trustee on behalf of the trust assets. So we would certainly want the trustee to sign that personal guarantee. And then, we just want to, it's a case by case. We want to look at who are all the players in the trust and kind of take a look at the type of the trust, what their interest is. A lot of times the beneficiaries, we may want the beneficiaries to also sign that personal guarantee. You could use a wait and see approach, wait till the interest comes out of the trust to the beneficiaries, and then have them sign at that time. But it could make sense, if we know that eventually it's going to come out to these beneficiaries, to just go ahead and have them sign everything and kind of pre-approve that transfer at the time of the initial transfer to the trust.
Okay. And as we move to the next slide on red flags, I'm going to tie this back to what you just talked about. Is one of the red flags where a franchisee is designating, say, a bank or financial institution to be the trustee? Is that a concern in these situations?
Yeah, well, for sure. The question would be whether, so an important distinction is, the settlor can name anybody that they want as a successor trustee under the document. So we might name X as the trustee and then name Y as the successor trustee. That doesn't mean that Y is going to be the trustee. Y has to accept that role. And so from the franchisor's perspective, we would certainly want them to be able to approve Y is a bank or trust company. But from a practical standpoint, the bank or trust company is probably not going to want to accept that role, or it's going to be a very specific bank or trust company who deals with these type of franchise arrangements, who's going to step in those shoes. It's not going to be your typical bank or trust company. But if that would be a red flag, that if you saw a corporate trustee named as a successor trustee, you'd want to ask some questions, and there may need to be some discussions with that bank or trust company. But again, if it's a triggering event, we don't necessarily have to deal with it at the time of the initial transfer. We can deal with it when they potentially could come on. So that could be an option. But yeah, I mean, that could certainly be an issue.
Okay. With the couple of minutes left, as we look at some of the details on pitfalls and red flags, are there one or two that you might want to emphasize?
Yeah, I'm going to emphasize the ones on transfers at death, because these are the ones that we see come up most frequently. And they kind of all ties back to this to creating a revocable trust. And it's not just creating the trust, it's funding the trust. So we frequently run into situations where we have someone die, a franchisee dies, they tell us that the franchisee entity is owned by their revocable trust. We request the documents, we get a copy of the franchise or of the trust agreement, but we don't get a copy of the assignment. So the individual has to execute an assignment to transfer that interest in the franchisee entity to the revocable trust during that individual's life. This is not something that can be done after death. So if it wasn't done, there's really no way to fix it. It becomes a probate asset, basically, and you have to go through the probate process. So from the franchisor's perspective, if we didn't already approve the transfer to the revocable trust during life and we're dealing with it after death, we want to make sure that we get that assignment so we can connect the dots to make sure that it was actually transferred. And then the last one is just the probate process. A lot of times franchisees will not be aware that they need to go through the probate process. If they have a will, it has to be probated. The executor named in that will has no authority until a judge actually appoints that person as the executor. So you have to go through the probate process, and there can be some education there for the franchisee. Okay.
We're going to move to our last substantive slide here, and just a few final points to wrap this up for us. Obviously, it's important that your franchise agreement, you review the assignment provisions so that a transfer involving a trust, you've determined whether or not it should trigger consent of the franchisor. And oftentimes you do want to make sure that it does trigger that. You may also want to put a provision there that allows you to recover a transfer fee, because there's often some review and cost time involved with a transfer to a trust. You also want to consider looking at your operations manual and whether you should include some policy that provides more detail on how you'll handle trusts. And then finally, communication to the franchisees in the franchise system. It's important, and it goes back to what Scott talked about with business planning, that you get the word out to franchisees so you don't run into situations of the principal owner of a business dying and it ends up in probate, which creates a lack of continuity on the franchise business. So with that, I'd like to thank everybody for joining us today. And if you have any follow-up questions, certainly give one of us a call or shoot an email out. And we thank you today for joining us.